Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello everybody, we're here today because Drizzen and Nyrider now have basically kicked it off. They've filed for their petition for a writ of certiorari with the U.S. Supreme Court. So they've done some pretty big things here, I think, and I think they're things that are going to very much work in Brendan's favor. The big main thing is the addition of another lawyer to the Brendan Dassey legal team. A very qualified lawyer, as you're going to see here when I get to that point in this video. So this is basically them just kind of laying out, you know, it goes through a lot of what's gone before. Basically, there's a lot of that in here, and then they talk about what happened over at the 7th Circuit and stuff, and then they go through everything. They go through why, you know, basically all the main points of why Brendan has been coerced. They're putting in a lot about all the social science research that's been going on to learn more about wrongful convictions and false confessions. So they're citing that social science research quite a bit in this. So it's really I think it's really written pretty well, and I think that you'll see that this thing is written by somebody who knows how to write in terms of what the Supreme Court justices want to see or would prefer to see. So anyways, so I picked out a few of the best bits, in my opinion, in this writ for certiorari, and this is just them filing now to get accepted to be heard by the Supreme Court. And so that's the step that they're at right now, and they're filing for their writ of certiorari. If their writ for certiorari is granted, then they get to, you know, file briefs and everything like what happened over at the 7th Circuit. So, but here it is. It's been kicked off, and you guys are going to see that this thing is written pretty well. I'm going to show you some parts of it right now, and we'll come on back. So this is basically just the opening of the writ for certiorari. In the Supreme Court of the United States, Brendan Dassey, petitioner, versus Michael A. Dittman, respondent, on petition for a writ of certiorari to the United States Court of Appeals for the 7th Circuit. Petition for a writ of certiorari. Brendan Dassey respectfully petitions for a writ of certiorari to review the judgment of the United States Court of Appeals for the 7th Circuit Court. Introduction. Whether a defendant's confession is voluntary is evaluated using a totality of circumstances test, Withrow v. Williams. But this court has made clear that not every circumstance is equally important. In particular, the court has long recognized that juveniles and those with intellectual deficits are at particular risk of confessing involuntarily and often falsely, under the strain of coercive police tactics. The court has thus held that the greatest care must be taken to assure that a minor's confession was voluntary. In Ari Galt, in accord with Gallegos v. Colorado, special care must be used. The court has similarly made clear that mental condition is surely relevant to an individual's susceptibility to police coercion, and hence is a significant factor in the voluntariness calculus, Colorado v. Connolly. In short, the court's precedent mandates evaluation of a juvenile's age and intelligence as part of a voluntariness analysis, Fair versus Michael C. In recent years, voluminous social science research has confirmed the correctness and importance of these holdings. That research demonstrates the extent to which minors and those with intellectual limitations are more susceptible to coercive pressures and consequently more likely to confess falsely. It has also documented many wrongful convictions that resulted from false convictions that imprison the innocent and leave the guilty free to victimize others. Okay, now we're going to move into a section that's basically named reasons for granting this writ, you know, essentially. So, and it's going to be, it has, you know, basically it's a lot of like, you know, the state courts and the appeals courts have really kind of been ignoring the Supreme Court's ruling that they need to give special care to these particular factors when it comes to juveniles, especially ones with limited, mental abilities. So, I mean, they're pointing out that at the state court level in the appeals courts that's kind of getting ignored, and that it would help, and ultimately it would help if the Supreme Court went ahead and reiterated or clarified or just restated that and just basically further punctuated the fact that juveniles require special care. It's it's already there on the books from the Supreme Court. I just think it's interesting that they're having to point out here that it's kind of getting ignored, because this, Brendan Dassey's not the only kid, that this happened to. I mean, he's not. He's, he's one that we all discovered and we all know now because of Netflix, but there's others like him. And there are other state courts out there ignoring Supreme Court precedent, and they're not giving due deference to these particular factors, especially when it comes to, those who are, of limited mental ability. So, like I said, anyways, we're going to move into the reasons for granting the writ here, and we'll come on back. Reasons for granting the petition. This court has repeatedly held that courts must employ special care when analyzing the voluntariness of a juvenile's confession, including doing an actual evaluation of the juvenile's age and mental state. Those repeated holdings have since been thoroughly validated and their importance underscored by extensive social science research, advances in DNA and related technology, and post-conviction exoneration efforts. Those developments collectively make clear that coercive police tactics are especially likely to elicit involuntary false confessions when applied to minors, particularly those, like Dassey, with intellectual and social deficits. At the same time, however, lower courts have often failed to follow this court's holdings, perhaps because it has been decades since the court has last ruled in this area. These circumstances warrant the court's attention, and this case is the right vehicle. The state court's departure from the court's holdings was stark and egregious. There is no serious doubt, moreover, that Dassey's confession was involuntary under a proper analysis, or that without the confession there was no case against him. Dassey should not spend his entire adult life in prison under these circumstances. The court should grant review. The decision below is wrong. Brendan Dassey was 16 when officers interrogated him 4 times over a 2-day period. He had no attorney, and for all but the brief third interrogation, no parent present either. Dassey's age and intellectual limitations made him highly susceptible to the officers' tactics, including their repeated feeding of key incriminating facts. Given the interplay between the officer's tactics and Dassey's vulnerabilities, his confession was not voluntary in any meaningful sense of the word. The Wisconsin Court of Appeals' contrary conclusion flowed from an objectively unreasonable application of this court's precedent. The state court utterly failed, as part of its totality of circumstances analysis, to afford Dassey's confession the special care this court requires for juvenile confessions. Gallegos, care that is most critical when, as here, the minor is borderline intellectually disabled. The court recited Dassey's age and intellectual deficits, but never conducted the evaluation of those attributes that this court's precedent mandates. Given the court's clear holdings, that was objectively unreasonable, as is clear from the paper-thin rationales of the en-banc Seventh Circuit embraced in denying relief. That's at the Seventh Circuit majority there. I love that. Because Dassey's confession was involuntary under a proper analysis, this court should grant review and reverse. So, I think what they're trying to make sure here is that the Supreme Court looks at this as basically a reaffirming or a reinforcing of their previous decisions, and possibly providing a little bit of clarification for today. Because like they're saying in this, you know, in their petition here, they're saying that it's been 40 years since the Supreme Court has ruled in this area. And they're, you know, and they think that that could be why some of the state courts aren't really paying attention to the totality of circumstances, particularly when it comes to minors with the age and the mental state. That states are kind of not really taking that seriously, maybe because they feel like the Supreme Court, because it hasn't ruled on that in 40 years, maybe it doesn't take that as seriously, you know, or maybe they just, maybe because there's not anything new, they feel like they can fudge that. I don't know, but I think it's a fair point. I think that the Supreme Court really does need to hopefully weigh in on this. I think Brendan Dassey's case is a good vehicle. I think it's an excellent vehicle. I think it's better than any other vehicle that you could possibly try to use. Because how many cases that get to the Supreme Court where they have the chance to really establish precedent? I mean, how many cases are going to have as many people are paying attention to Brendan Dassey's case? I mean, that's what makes this case a good vehicle. And if they go ahead and now reaffirm and basically, you know, issue a judgment in the present day, and making, you know, all the lower courts aware, you need to be paying attention to these social science, you know, experiments, and you need to start paying attention to this stuff because it's important. And this is why this decision was, this is why we said you needed to take special care with juveniles 40 years ago, type of thing, where they lay it out going, look, this is not playtime. We're not kidding around. We expect you to take this seriously, you know, kind of thing. Because we don't really, what we really kind of don't want is we don't want them to make new law. And I think that's why they're being so keen to point out that this just needs to, that really what needs to happen is just a clarification of special circumstances by the Supreme Court. Because if they make new law, that kind of doesn't help Brendan very much. If they make new law because of Brendan, it doesn't let him out. He doesn't get out if that happens. He basically would have to go back to the beginning and start all over again, basically where he started 10 years ago. So, and they'd have to find some new evidence, or what, you know, they'd have to bring the case so that it applied in a way to the Supreme Court's new law that they just made, I think, or something like that. I think it goes along those lines, but essentially making new law is not exactly what we want. We want the Supreme Court to further clarify special circumstances and how there's and for the lower courts to understand that they need to take special care, especially when you're dealing with a juvenile who is of limited mental capacity. It's absolute. I mean, it's a no-brainer. I mean, it's really a no-brainer. Sorry. But anyway, we're moving into the next bit, and we'll come on back. Dassey's confession was involuntary. When as here a state court decision satisfies 2254 D1, federal courts review the habeas claim de novo, unencumbered by the deference AEDPA normally requires. Such review leaves no doubt that Dassey's confession was involuntary. The voluntariness inquiry first requires consideration of the characteristics of the accused. As discussed, Dassey was 16 when he confessed, had no significant experience with law enforcement, and suffered from intellectual and social disabilities that rendered him exceedingly vulnerable to suggestion. The social science research discussed above and this court's precedents makes clear that such an individual is particularly prone to submit involuntarily to police efforts to elicit a confession, even if that means confessing falsely. The voluntariness inquiry next mandates consideration of the details of the interrogation. Because coercive police activity is a necessary predicate to an involuntariness finding. Here the interrogators employed several tactics to minimize the range of responses Dassey could provide. For example, when Dassey made wrong guesses, they used warnings like "tell the truth" or "tell the truth," which is code for "guess again." And when he guessed again in a manner more consistent with the officer's preconceived narrative, often guided by their fact feeding, they provided positive feedback like, "That makes sense, and now we believe you," as code for "That's what we want to hear." The officers also used promises, telling Dassey that if he was honest, he would be set free. As Judge Rovner expounded, this combination of steering language and promises of release constituted a perfect example of operant conditioning. I agree 100% that they were using mental conditioning on Brendan. I've been saying that since some of my very first videos. As just mentioned, moreover, the officers also engaged in repeated fact-feeding, effectively asking Dassey to confirm facts rather than to provide his own account. Time after time, they tried to get Dassey to provide information about particular points while telling him they already knew, repeatedly engaging in ghoulish games of 20 questions in which Dassey guessed over and over again before he landed on the correct story, i.e. the one police wanted. The officers did this with the key facts that Halbach had been shot and that the shots were in the head. Non-public facts that Dassey never guessed correctly, but was instead fed. They did it regarding to what happened to the license plate on the Halbach vehicle. Dassey could not say what happened, so officers gave him their answer and let him agree. The license plates were taken off of the car. Who did that? Answer: I don't know. Question: Did Steve do that? Answer: Yeah. They did it regarding where on Avery's property Halbach was shot. Dassey initially stated she was shot outside, but that was inconsistent with the shell casings recovered from Avery's garage. So the officers pressured Dassey to move the shooting into the garage. Once Dassey did so, Wiegert said, "That makes sense. Now we believe you." And they did it regarding evidence that Halbach's car battery had been disconnected. When their questions failed to prompt Dassey to admit that, the officers simply said it themselves so that Dassey could again just agree. Fassbender: Okay, what else did he did something else. You need to tell us what he did. After that car is parked there, it's extremely important. Before you guys leave the car. Dassey: That he left the gun in the car? He left the gun in the car. I mean, at what point do the ridiculous guesses tip these officers off? Yeah, anyways. That is a ridiculous guess, by the way. Anyways, that's not what I'm thinking about. He did something to the car. He took the plates and I believe he did something else to the car. Dassey: I don't know. Fassbender: Okay. Did he go and look at the engine? Did he raise the hood at all or anything like that to do something like that to the car? Dassey: Yeah, I don't know what he did, but I know he went under. So that's them feeding him the information, and he just agrees. So here again, Dassey demonstrated ignorance of a key fact, guessed wrong at what the officers wanted, no gun found in Halbach's vehicle, and finally had to be told what the right answer was. With each of these fact feedings, and there are more, the officers gave Dassey two options: keep guessing at what the answer they wanted, and ultimately agree with the answer they provided in an effort to end the interrogation and return to school, or 2, profess a lack of knowledge and generate negative feedback from his interrogators. And that's, basically that's the mental conditioning that they had him in. They had him pinned between these two forks, or this one fork in the road, and then they just kept working it. So Dassey's passivity and acquiescence continued even when the officers fed him false facts to gauge his truthfulness. For example, they asked Dassey about a tattoo they knew Teresa didn't have. Rather than refute the officer's assertion, Dassey second-guessed himself into agreement. Fassbender: Okay, we know that Teresa had a tattoo on her stomach. Do you remember that? Dassey: No, Fassbender: Do you disagree with me when I say that? Dassey: No, but I don't know where it was. Okay. So he basically ends up agreeing because he's afraid to say that he disagrees with Fassbender. That's what's happening there. That is not resisting, as the Seventh Circuit majority try to say. That is absolutely waffling because he's afraid to disagree with Fassbender. So anyways, although the en banc majority presented this as an example of Dassey pushing back against his interrogators, it demonstrates the opposite. Even when confronted with an affirmatively false assertion, Dassey acquiesced, hedging his response until he received the officer's confirmation. The control question. Yep. All I'm going to say. So, next part we move into is basically where they explain right now that this case, Brendan's, case, is an excellent vehicle. It's an excellent vehicle for the Supreme Court here to make a decision, to clarify special care and all that and special circumstances and all that stuff. I mean, this is a perfect opportunity for them to clarify and reiterate and make sure that all the lower courts understand where the Supreme Court stands on this, because a lot of people are listening. This case has a lot of people's attention. No matter what you want to say, a lot of people are paying attention to it. A lot of lawyers are paying attention to it, and a lot of citizens, actual citizens, are paying attention to what happens in Brendan's case. They are interested. So, that is, in my mind, one thing that makes this absolutely an excellent vehicle for the Supreme Court to make clear what they mean by special circumstances and special care. So, we're going to move into that right now, and we'll come on back. The case is an excellent vehicle. For 3 reasons, this is an excellent vehicle to reiterate and apply the requirements for assessing the voluntariness of juvenile confessions. First, because of the entire March 1st interrogation was recorded, there are no relevant factual disputes. The video transforms what could be a muddled factual inquiry into a cleanly presented legal question. Unlike a transcript, moreover, the video shows physical movements, facial expressions, tone, and pacing. Wiegert repeatedly touched Dassey's knee, describing the volume of the officer's questioning, noting the pauses between questions and answers. That would allow for more extensive guidance from the court. Second, Dassey's confession was, as a practical matter, the entire case against him. Indeed, as the panel below explained, despite the intensity of the investigation, no one ever found a single hair, a drop of blood, a trace of DNA, or a scintilla of physical evidence implicating Dassey. The prosecution failed to offer any DNA evidence connecting Dassey to the crimes, despite extensive testing. Consequently, there is no doubt that Dassey's confession, probably the most probative and damaging evidence that can be admitted, drove the jury's guilty verdict. Finally, the disagreement between the en banc and panel majorities and dissents turned on how to interpret the Wisconsin Court of Appeals' silence with respect to the special caution required by Dassey's age and intellectual and emotional deficits, because the degree of scrutiny applicable to the state court's cursory voluntariness analysis was dispositive. This case would allow the court to provide guidance both to state and federal courts applying its precedent in the first instance, and to habeas courts addressing claims under AEDPA. Conclusion. The petition for a writ of certiorari should be granted. Respectfully submitted. Okay, so that's basically, the legal team's explaining why this case is such a great vehicle for the Supreme Court to, issue a judgment here to help reinforce prior judgments in the past. So, and why it would be good, because of this case, it's just like I said, that many people are paying attention to it. Whatever happens with it, people are going to know about and remember, at least a good portion of people. So, anyways, now we're going to move into what I was talking about earlier in the video, and that is the new addition to Brendan's legal team. And he's got quite a few feathers in his cap, but I think most importantly is that he's argued in front of the Supreme Court himself before. But not only that, he was a Solicitor General for a while. That means he has some pretty intimate, knowledge and understanding about how that place, works and what goes on there. So I think that's excellent news. Really do. I think that's an excellent addition to Brendan's legal team. And so I'm going to show you a little bit from an article right here about him, and then we'll come on back. Dassey had substantial intellectual and social deficits, according to his petition, which was filed by longtime Supreme Court practitioner Seth Waxman, a former Solicitor General under President Bill Clinton. Put simply, the interrogators took advantage of Dassey's youth and mental limitations to convince him they were on his side, ignored his manifest inability to correctly answer many of their questions about the crimes, fed him facts so that he could say what they wanted to hear, and promised that he would be set free if he did so, Waxman wrote. The resulting confession was more theirs than his, and that is absolutely true. That's like nail on the head right there. Perfect. Bam. So, I think things are looking at least positive for Brendan, I will say. I think he really has a darn good chance. I mean, there's so many people interested in his case, so many lawyers. There's just going to be, I can't wait to start being able to read maybe some of the amicus briefs that are going to get filed with this case. I mean, there's going to be some real good ones. We're going to see what's going to be happening here. Obviously, it just got filed today. And so maybe over the next couple weeks, that's when we'll start hearing about amicus briefs, getting filed and stuff like that. Would be awesome. So, anyways, that's it for today, people. That's the news that everything is moving forward with Brendan's case, and he's attempting to get it. He's attempting to get in front of the Supreme Court. And God bless Knight Rider and Drizzen. They went out and got themselves a big gun, somebody who's going to help them greatly. I think, because that person understands the way that this Supreme Court works, and that person understands what the justices look at and what they're looking for, what they respond to, what they don't. I mean, it's good to have something like that. That's really, really, just smart move, and I really feel good for Brendan right now. I really think he's got a good chance of getting seen by SCOTUS. So that's about it, folks. We'll see you later. If you haven't already, please hit subscribe.